If it pleases my lords,
Yes,
my lord the Chief Justice and the judges of the Supreme Court, I will split my presentation in 9 points that deal with the prejudice to be occasioned by the order sought to the third respondent. I begin, my lords, with the characterization of the application made before you. What is before you is in truth not a scrutiny application, but in fact an application for an audit. And there is a significant distinction to be drawn between an audit and a scrutiny. I rely not on my own authority, but on the authority of this court and our own courts here. My lord, the judiciary prepared a very helpful bench book on electoral dispute resolution, and I refer you to page 78 of that document, which is available to all of us. I got a copy from the judiciary website. And in particular, paragraphs 4.6.5.1. The point it makes, my lord, is this, is that a scrutiny inevitably entails the conduct of a recount. I have read that statement verbatim from that particular document, but that the converse is not always true. Now, as we've seen this morning, we run then into the danger of converting the scrutiny into a trial within a trial. We start examining evidence peremptorily at the beginning. My learned friend, Mr. Mahat, has done a fantastic job explaining what they have provided. My lords, what we did when we received the affidavit of Mr. Silas Njero is quickly do an audit of what had been provided. And what we've done at page 68 of our affidavit, which we have provided to you, we have prepared a table documenting everything that we got there. And one of the dangers of this, and this is one of the prejudicial issues we are to raise here, is the danger of information or data overload. The information given is not, in fact, 40 gigabytes. It's actually 48 gigabytes from my examination yesterday. Now, I read history to do my law, and so I've had to do some tuition yesterday to understand exactly what that means. But beginning at page 68, we do a checklist of everything that we have been given, some of which was already available. You will find, for example, in the affidavit of Mr. David Chirchir, in response to the affidavit of Mr. Njonjo Moe, a 600-page document of the logs obtained from the KIEM kit. This is available on the website for IEBC, free of charge to every Kenyan and indeed to the entire world for examination. Now, you will then find 13 items we have listed in that particular document. And at the bottom of that list, and you will find that at page 70, we have done a quick analysis from our experts what that information means. Now, apparently 48 gigabytes, and I can cut down quickly to the chase. When broken down into megabytes, that is 48,000 megabytes, and I am told that 2 kilobytes has about 500 pages of information. The 48 gigabytes supplied to all of us is 24 million documents. That is the information that has been provided in that particular document. Even if we were to assign a 100-man team to look through this at the supersonic speed of a second per document, we'd be here at least for 3 years looking at that document. We'd be here looking at that information. And so that is not an idle complaint, my lord, because you dealt with it in the case of Nadhif Jama Adam versus Abdikarim Osman Mohammed. My lords, we have filed before you a decision you will find at page 5 of our bundle of authorities, where you addressed the question at paragraph 80 of the consequences of inability to deal with material and time. Overloading parties with 24 million pages of documents is an Article 50 infringement. We cannot, within 14 days, look through 24 million pages and come up with anything resembling a judicious finding. It is impossible, my lords. But again, my lords, our memories are fresh. At paragraph 403 of your majority decision, you, I think, directed the problem to where it should be, which is Parliament. And I think you said that Parliament has been asked time and time again, please expand the time for us to do this. But you said that in the meantime, we do not have sufficient time to do things like a scrutiny. And so, my Lord, that, and I did a count again yesterday, the information availed during the 8th August election petition was 8 gigabytes. What we've been given now is 6 times what we were given. And on that occasion, at least on the Form 34As, the scrutiny only managed to go through 4,000 forms or so. We now have 8 times that to look through. The third item under the Article 50 prejudice issue we raise is the one my learned senior has discussed, and again you'll find that properly articulated in the Nadhif Jama case, is that we do not know what case we are to meet and respond to. And a fourth issue, I think, which arises from that, my lords, is Article 140, Sub-Article 3, and I think my learned senior, Mr. Ngati, has made that point while he was here before, makes it very clear what you're to file and within what time. The introduction of all these new documents at this late stage has the functional effect of reopening the petition out of time and in violation of Article 140, Sub-Article 3. I then now move to certain areas that perhaps were not covered by my friends here before. One of the areas that has been attacked by the petitioners before you is the question of the voters' register. Now, the voters' register in electronic form has been available on the IEBC website since at least the 9th of June 2017. The KPMG audit, that was a statutory mechanism, I believe under the provisions of Article 7, 8, or 9, or 10 of the Elections Act, was released on the 9th of June 2017. Attached to that, and my learned friends from the petitioners have skipped that from their presentation, was a list of dead voters and those who had shared IDs. My lords, I have taken the time to produce that for you at pages 12 to 20 of our replying affidavit. There's a list of those which was part of that report. Now, what then happened, my lords, is that the IEBC then opened up the register for verification on the 10th of May 2017 by way of a Gazette notice. You will find that Gazette notice at page 21. The purpose of that opening of the register was so that the complaints they bring here today could be examined and brought before a court well before the election dates. On the 27th of June 2017, the IEBC closed the register as required by law, and you will find the Gazette notice for that at pages 22 to 48. They then closed it again after the elections. I believe they closed on the 5th of September 2017, pursuant to the provisions of Section 5, Subsection 1. You will find a Gazette notice at pages 49 to 50. The point of all this, my lord, being this: they have had since at least June to come and challenge any aspect of the voters' register they wished to do. They come on the eve of the hearing of a time-constrained 4 or 3 petitions and say they want that opened up all over again. And this is not the register that was merely used for the fresh presidential election. This is also the register that was used for the general election itself. I go to the next point. The application is in fact designed to circumvent statutory limitations set out at Section 6 of the Access to Information Act. Section 6 of the Access to Information Act sets out limitations to information that cannot be given or that is not available to be given under that statute. It is also an attempt to circumvent Section 27 of the IEBC Act, again, which sets out limitations as to what information can and cannot be given out and within what time period. In other words, my lords, Article 35 is not an unlimited statute granting rights to information. Indeed, the purpose of these statutes, and including Article 35, is to grant information where that information has been refused. But as demonstrated here by my colleagues before me, That information has been readily available and has been granted to all these parties. Now, the party before you, and this is another point now, has a special place. In the affidavit of Mr. Njonjo Moe, I believe it's the first 6 or so paragraphs, he states that he is doing this as part of a group of civil society organizations called Kura Yangu Sauti Yangu. And he then says that they are indeed accredited observers under the provisions of Section 42 and Regulation 94 of the General Regulations. Now, when the IEBC provided this information, the notice was very clear. They said, this information is available to observers, candidates, and their agents from as early as the date the results were announced. And so they've had 10 days to have obtained all this information as a matter of right and public notice and record. They cannot come at this late stage and tell us they want to burden us with all these millions of documents, having filed their petition. And indeed, it's instructive that we began our session this morning with the same petitioner coming to say they did not have enough time to even file the little they have. They did not have enough time. They now want more time to file another 24 million pages, which cannot be examined at this late stage. There is an issue that has been raised here as regards, and I think maybe before I go to that issue, perhaps I should say closing and circumvention of the statutory provisions. The framework for managing our elections has certain sections embedded in it for the provision of information. For example, Section 39(1)(c), subsection C, has a requirement that forms are to be uploaded on a portal. It is a statutory requirement. As of the date of filing this application, and indeed in a day or so, of the time the results were being announced, I checked. There are 37,187 Form A's uploaded, available free of charge to Kenyans and indeed the entire world. There is 266 Form 34B's available pursuant to that statutory provision, and there is a 364-page Form 34C again, also on that website, available for verification and inspection. And so the mechanisms provided by law, and my lord, I think the point has also been made here, that Section 12, subsection 2 of the Elections Act makes provision for certified copies of Form 34A, B, and C to be delivered to this court. Now, this was a provision that was amended. It was a provision that was brought in together with 39(1)(c), subsection C, during what came to be known as the Kiraito Orengo Joint Committee report. And those forms are here. The danger and the prejudice we run, the risk we run here, is having so many forms that we start making mistakes because of data overload. We cannot tell which are the proper forms here. We cannot tell which ones came at what point because we have 24 million pages. It's not humanly possible to look at all those, at all that material. Now, some of the other prejudice we've raised in our replying affidavit, my lord, is an issue raised by Section 27 of the IEBC Act, and it's an issue to do with confidentiality of information.
Mr. Majaria, you have less than...
1 second, my lord, or 1 minute, I think.
Yes.
One and a half minutes, my lord, yes. I will try and fit in everything I have to say in that point, my lord. The point is this. Section 27, and my lords will have a look at this, has provisions regarding the confidential treatment of information. Among the things you will see we have attached before you here are 2 letters which you will find at pages 51 and page 60, dealing with what happened when this honorable court, as it was entitled to do, granted an order for access to IT systems at the IEBC. The next set of things that happened, of course, was that the deponent of the affidavit himself, Mr. Davis Churchill, found himself the branch of attacks on the basis of what was or was not in those servers. This was information that had been provided pursuant to the court order and information that had been provided by the IEBC itself as part of the transparency requirements. Those complaints are now the subject of criminal investigations. And so, my lords, some of the information sought here, without proper mechanisms and without proper safeguards as to the confidentiality of that information or as to how it will be used then leads to prejudicial results. My Lord, permit me to state a few things from what my learned friend, Ms. Julie, said. She said they want the full picture and that quick results came after 15 minutes, and that's one of the grounds. The problem with the 8th August election was that the results came too slowly.
Mr. Macharia,
yes.
Your time has run out.
Thank you, my Lord.
So find a way of winding up in a minute.
Yes.
Yes.
I think, my Lord, maybe let's me end with a figure, because this is what we're here about. You've been told there are 19 polling stations that that they've identified for purposes of this scrutiny. Again, to give a figure, those represent, and those are the only ones they've mentioned in their pleadings, 0.05% of the polling stations where an election was conducted. That cannot be a basis, my Lord, even from a numerical perspective. If this were a medical test, it would come out negative, for scrutiny positive, my Lord. Thank you very much, my Lord, for listening to me and for granting me a bit of extra time to say what I need to say. Thank you.
Thank you very much, Mr. Macharia.